Yes, Master.
My Lords, I was on the legal answer to my Lord Hughes's point, and I was going to take you to AS4. I'll just give you references, if I may, given the time. The references are to Lord Bingham in AS4 at 16, 22, and 25. The key point is that Lord Bingham, in the 3-2, for the 3-2 majority, says that subsection 2 apart, not 31(1)(c), but 31(2), apart from that, no indication was given of an intention to depart from a demi. And therefore, and you have a similar approach in Lord Hope at 56, 65, and 67. So he said, 65, subsection has narrowed its scope in comparison with what was contemplated in the demi, but the section as a whole indicates that once the prerequisites are satisfied, the defence will be available in all cases that are within the reach of the article. So the only room for doubt is 31(2). 31(1)(a) and C are two sides, well, it's just codificatory. That's what the House of Lords say by a 3-2 majority. And it's very clear. And in a sense, my Lord, if anything, 1A without delay, because it doesn't expressly have reasonableness built into it, is stricter than claiming as soon as reasonably practicable, because that has reasonableness explicitly built into it. And that is not only the approach of AS4, it's also the approach of the Court of Appeal in the case I mentioned, the Mateta case, Lord Justice Leveson. I've given you references for that. It's volume 5, tab 38, MS 1463. AS4 is really important for another reason, because one might say that use of the false instrument to cross immigration control isn't necessary to claim asylum. It's a point that Lord Justice Pitchford made at 74 below. It's a point that my learned friends make in their case at 144. But Lord Bingham, again, is the complete answer, because he says, in a passage my learned friend took you to, Mr. Hermer, at paragraph 9, MS 117 of AS4, it's quoted in our printed case, paragraph 15, MS 4588. He says, if you recall, the third aim of the Convention, broadly expressed, was to protect refugees from the imposition of criminal penalties for breaches of the law reasonably or necessarily committed. And Lord Bingham, of course, my lords will well remember, there's hardly ever a word out of place in his judgments. It's deliberate, we say, because he contemplated, we say, that the protection doesn't extend to breaches of the law that are necessary for the claim, but are reasonably connected to it. And that makes perfect sense, because if you arrive and before you reach immigration control, you make the claim, you've not committed any entry. You've not attempted to enter. You haven't entered. You've simply arrived. And there's a famous case of Nali and Canastaraja which draws that distinction. We haven't got it in the papers, but I'll give you the reference if you want it. It's 1993, appeal cases 674. There's a distinction between arrival and entry. So you wouldn't have committed an offence. There's an argument about whether or not, if you didn't have a passport, you'd thereby committed an offence under Section 2 of the 2004 Act, but there's a reasonable excuse defence to that. Leaving that aside, essentially you wouldn't have committed an offence. But of course, my lord, Article 31 is predicated on illegality. It contemplates an offence. So you're emptying it of application. If you say, look, there's no reason for asylum seekers who arrive here, it's a safe country, why on earth don't they just arrive in the arrivals hall? And that's the answer. Claim in the arrivals hall. And of course, Lord Justice Simon Brown has said that there is no need for a voluntary exonerating act, as he put it, in Ademi at MS 80 679 C and H. So those are legal and human answers to that point. Coming directly, I'm going to take very, very quickly. It's clear that neither the short-term transit in Holland, and indeed the previous state, broke the disqualified the appellant from Article 31 protection or Section 31, nor indeed the state in Yemen. Just one reference, UNHCR 1999 guidelines, paragraph 4, volume 1197, at 3574 to 75, quoted by Lord Bingham, endorsed by him in AS4 at paragraph 13, refer to a state where protection, safety and security can't be assured. Protection, safety and security could not be assured in Yemen, given the desperate conditions there, nor for that matter could you have an exercise of all the rights other than non-refoulement. Refugee Convention is principally about the other rights. It's a convention relating to the status of refugees, not just simply protection from return. All that material in between Article 1 and 33 that the courts have looked at from time to time. Penalty, as I said, you don't need to decide it. I just want to take you to one passage in our case that references paragraphs 56 to 57, where we underline, and 56 to 57 is at MS 4602, where we underline the need for proper systems to identify refugees who potentially benefit from that provision. That's in the expert roundtable conclusions and also in Professor Goodwin Gill's background paper, which was described as a very thorough piece of work by Lord Justice Simon Brown, as he then was endorsed as such by Lord Bingham. And that is, my lords, a segue into the final substantive point which we make about delivery. We outline the current policy at 71 and 72 of our case. It hasn't been operated properly over the years. See our case at 77. There is one particular case which we take issue with respect, and that is the Makua decision. You've got Makua at 537, and it's at MS 1429. Our printed case at 30 to 37, and again 82 to 86. The first part of our printed case addresses the problem in Makua that it rejects the presumptive refugee analysis. Article 31 applies to presumptive as well as actual refugees. The protection ceases if your claim is rejected. There is a proviso where UNHCR say, very logically, that if in fact you fulfill the refugee definition conditions at the point of arrival, at the point of penalty, at that point, then you ought to have the protection of 31 because refugee status is declaratory. If there's a 3-year delay because the state is waiting to determine your claim, it can't then say, oh, you're not a refugee, therefore you don't get Article 31 protection. But that's a really important point. We say that the fact that the protection extends to actual as well as presumptive refugees answers two questions put by my Lord Mance. My Lord asked whether if you subsequently discover that the individual is not a refugee, does that retroactively validate your preceding action? Yes, it does, because you're disentitled from the protection subject to the proviso I gave. And my Lord also asked the question, well, you only had a right of entry if you were in fact a refugee. That's just not right at all. If you think about Article 14 of the UDHR, that says everyone shall have the right to seek and enjoy asylum. So Article 31 and Section 31 properly construed, we say Makua is wrong on this for the reasons we give you at 30 to 37 of our case. Article 31, Section 31 properly construed protect actual and presumptive refugees. The next issue which we have with Makua is a serious one because right at the outset of the hearing, my Lord Toulson asked the question or made the observation that the burden's on the refugee to prove the defence subject on balance. And that's something which is very much in evidence in my learned friend's case at the beginning of his case. And this is, of course, something upon which Lord Justice Pritchard relied at paragraph 73 of his judgment. And we say that that is totally illegitimate because quite apart from the principled reasons which we identify in our printed case at paragraph 79 and following, it is very clear that the purpose of the section was not to impose a legal burden on the individual. Can I just show you one passage?
Oh, I think your time is really up.
Mr. Hermer, I was worried that I might be. I'm just going to be 2 more minutes, if I may. Mr. Hermer very kindly indicated that he would give me 2 or 3 minutes of his reply. He's got 30 minutes. So if I can carry on, I'd be very grateful. I'm sorry to seek my Lord's indulgence. Perhaps I'll just give you the references. So in Hansard, that was not before the Court of Appeal in Makua. In the context of a debate, the Attorney General, Lord Williams, made it very clear that the purpose of the defence was for the defendant to raise it and for the prosecution to disprove it. And he says that, Volume 9, tab 71, MS 2848, 2849. There are 2 passages there where he makes it very clear. That was, of course, Lord Justice Simon Brown's view. He deprecated the idea of abuse as the proper vehicle, precisely because abuse put the burden on the defendant, whereas he wanted it's Article 31 to operate by way of a defence where the burden would be on the prosecution. And the reference there is 683E to F in Ademi, MS 84, 683E to F, MS 84, Volume 1, Tab 3. And Ademi is very, very important, not only because Lord Bingham endorses it, but also because, as he put it, it loomed large in the debate, and Lord Williams, the promoting minister, the Attorney General, wanted to accommodate it. That's his phrase. And it's very clear, we say, that Makua here is wrongly decided for the reasons we've given you, and for that additional reason. Can I just address just 2 sweeping points very quickly? One, my Lord Toulson's point about public interest, that's just simply a policy. Well, it's mandated by statute, the 1985 Prosecution of Offenders Act. You have that at Volume 2, Tab 11, MS 277. That's one point. The other sweeping point is my Lord Mance raised the issue of whether an offence ought to have joined the UKBA as a second defendant. Well, the obvious solution for Mr. Havers' client was to Part 20 them, third party in old money. If you go against Party X and he says it's Y's fault, the answer is to join them as a third party. It's obvious, with great respect. By way of conclusion, we say that in this case, it's just four very quick points by the reason I sit down. I'm sorry for the time I've taken. Here, there was a clear breach of Article 31, whether actual or prospective. It doesn't matter for Article 8 purposes. Contrary to Lord Justice Simon Brown, Article 31 has not henceforth been honoured, far from it. This case is an example of systemic and operational failures. Thirdly, the conduct protected or contemplated by Article 31 is worthy of respect in the sense that the individual has a reasonable expectation, indeed a right, to undertake it. Therefore, Article 8.1 is plainly engaged in these sui generis circumstances. Lastly, what can we rhetorically say be the possible justification for prosecuting a refugee contrary to this unique sui generis protection? The only candidate for justification is if the facts aren't clear, but a badly designed system and operational failures are no answer. Thank you very much, my lords. On behalf of UKSC, those are my submissions.
Yes, Mr. Luckers. Thank you. Yes, Mr. Havers.
Lords, may I begin with 2 preliminary observations? The first is to remind your lordships what this case is actually all about. It is a private law claim brought by the appellant against the CPS, in which she alleges that the decision to prosecute her, taken on the 28th of December 2009, violated her Article 8 rights. It is not a public law challenge of some sort to that decision, or to the respondent's policies, guidance, or to its procedures, nor, I may add, in the light of the Commission's submissions, is it a challenge to the Convention compatibility of Section 31 itself, or an appeal against some of the Court of Appeal authorities complained of by Mr. Hussain. And thus, if one ever gets to Article 8.2 in this case, the decision has to be assessed by reference to what was known at the time, that's to say the time the decision was taken, which depended on what the UKBA had told the CPS, and it does not depend on what subsequently turned out to be the position following the UKBA's detailed assessment of the appellant's asylum claim. Second preliminary observation, the claim was, in fact, originally also brought against UKBA. They were one of the original defendants to the claim, as indeed was the relevant chief constable. But the claim was not pursued against the UKBA. That was the choice of the appellant and her advisers not to do so. Lords, can I then respond briefly to some of the facts as put before your lordships by Mr. Hermer this morning? I hope briefly, before I turn to the important issues of law that are raised on this appeal.
Does the CPS have separate legal identity for this purpose?
Yes, my lord. The defendant who was sued originally was the Home Office, of whom the UKBA were. I think they've been disbanded since, but I think of whom they were an agency or a branch. And the Home Office was the party that was sued, the government department that was sued on their behalf.
And what actually is the CPS?
Well, that's, I think, a freestanding public authority.
Is it a statutory
set up,
corporation?
I'm sorry, my lord.
Is it a statutory corporation, or is it?
Lord, I seem to recall it was set up in the 1980s.
It's the Prosecution of Offences Act 1985.
That's it,
But
yes.
what-
Yes, my lord.
But that doesn't answer my Lord's question, I'm afraid.
I don't need to know the answer now. I was just curious.
Lord, can I take notice of your lordship's question?
But anyway, your point is that the target is confined to the CPS, but it might just be helpful to have a bit more assistance on what the CPS is. And,
Well, Lord, I can certainly do that, and will do so. Lord, so far as the facts are concerned, as I say, I propose only to respond briefly to various.
Well, how far are we engaged on an exercise involving looking at every single step in the course of the prosecution? I don't find that analysed in the judgments below, I think, although there's a description of the process in the first instance judgment.
Well, no, that is our first submission. Your lordships are not engaged upon that exercise because of the narrow compass of the claim that is brought against the CPS. Indeed, although your lordships were taken to the appellant's reply, where there was a passing reference to the maintaining the prosecution, when the case came before the judge at first instance, we can see from the first page of his judgment, it's MS 4090 in the appendix, that he opens his judgment by saying, this claim concerns a decision to prosecute the claimant for an offence under Section 25 of the Identity Cards Act 2006. The claimant alleges that on the facts of her case, the decision to prosecute her prior to consideration of her individual circumstances and/or determination of an asylum claim, and to prosecute without reference to the merits of that claim represented a breach of Article 8. So by that stage, the scope of the claim had reverted to the decision taken on the 28th of December. Lords, if I may, dealing briefly with some of the points raised by learned friend on the facts, albeit in the context of Article 8.2. First of all, he sought to rely upon what he said the judge had found on the basis that the judge had found that the decision maker, if the decision maker had known that which the judge had identified, the prosecution would not have proceeded. Your Lordships were taken firstly to paragraph 43 of the judgment, which is at MS 4100. Where he says 2 or 3 vital facts, if they'd been communicated to the CPS, might well have altered the decision to recommend prosecution at the outset. Had the CPS been advised by UKBA, or had they known of their own knowledge, that an individual such as the claimant could not obtain valid travel documents in Somalia, it seems to me this would have been bound to be thought significant. In that situation, no lawyer would require, and so on. And then the UKBA were clearly aware of this fact, but never informed the CPS. And then 44, the CPS were misinformed about the Yemen, and so on. And then at the end of his judgment, paragraph 92, MS 4110, he actually refers to not only the fact that no Somali could obtain genuine travel documents, but goes on, and that it was practically impossible to seek asylum in the Yemen, then the decision would probably have been not to proceed, but to await the outcome of the asylum application. Now, the second part of that, that's to say it was practically impossible to seek asylum in the Yemen, again depended from the CPS's point of view entirely upon firstly what they were told by UKBA, and secondly, upon UKBA's own detailed assessment of the application for asylum. And at this point, can I just take your Lordships to the asylum decision, which your Lordships will see beginning at page MS 4264 in the appendix. And go, please, to 4280.
Yes, thank you, I've just got this.
Where a lengthy section addressed to the conditions in the Yemen begins. And your Lordships will see that the UKBA had carried out detailed analysis of the position in the Yemen by reference to a variety of sources of information, the US Committee for Refugees and Immigrants, above the first punch hole, paragraph 36, and then further information, paragraph 37, and so on. I'll leave your Lordships to read it in your own time. But the reference in the judgment to the position in the Yemen was something which was only addressed by the UKBA once it turned to investigate the appellant's claim for asylum in detail, and this was the product of their detailed assessment. So realistically, not only did the CPS not know of the position in the Yemen at the time that the decision to prosecute was taken, but they were never going to know until the UKBA had carried out that detailed assessment. Now, Mr. Hammer then went on to refer to the evidence of one Pam Bowen on the basis that the CPS, one can derive from her evidence, institutionally knew that Somalis could not obtain a valid passport, and he gave your Lordships the reference. The judge, in fact, didn't, I think, make any finding to that effect. But even if he did, of course, that that only took the judge so far, because in the passages I've just shown you, that was paragraph 42, he only said that that might have made a difference, and he only concluded, see paragraph 92, that it would have made a difference when he added to the position about the passport the true position in the Yemen, which, as I've emphasised and I hope shown your lordships, only emerged once the UKBA had carried out its detailed assessment. My Lords, next, Mr. Hermer complained that there had been a failure even to comply with the CPS's own code for Crown prosecutors. He hasn't explained how that in some way cross-refers to Article 8. But his principal complaint was that the prosecutor who took the decision to prosecute had failed to take into account the individual circumstances of the claimant. Can I hand up to your lordships at this point a document which was left out, unfortunately, of the appendix, but was before both the trial judge and the Court of Appeal? And it's a document that belongs, we suggest, immediately in front of MS 4356.
Thank you.
And your lordships may want to number it 4355A.
Now, this explains why the document we have starts B. I was looking for an A.
Exactly.
This is it.
That's the missing A. And if your lordships just as it were, put that document together with 5356, you can see that at the foot of page
4356.
I'm so sorry, 4356. Your lordships can see that at the foot of the page, the document I've just handed up, she stated that she'd left Somalia in December, and it may have been blanked out on your lordship's copy. That's 2008 by boat to Yemen. Yeah. So this is the report this is the report that's sent to the CPS, as it says at the top of the page, report to Crown Prosecutor for charging decision. And your lordships will see halfway down the page, outline of circumstances and decisions by sort. And then there's then set out a summary of the police interview, which had not long before, the same day, taken place. And your lordships will see that at MS 4286. And just a glance through that summary, particularly over the page to 4356, indicates that the CPS prosecutor was therefore informed to a significant extent of the individual circumstances that apply to this individual. And then when one goes to section B that my Lord Ormance just referred to at 4357, in the public interest box, a little over halfway down, you will see that the lady who took the decision, her name appears at the foot of the next page, Jo Golding, under public interest, says, I have noted paragraphs 5.6 to 5.11 of the Code for Crown Prosecutors. And if your lordships would just go on to MS 4388, your lordships will see that paragraph 5.8 expressly refers to the individual circumstances of the suspect. Top of the page, Crown prosecutors must balance factors for and against prosecution carefully and fairly. Public interest factors that can affect the decision to prosecute usually depend on the seriousness of the offence or the circumstances of the suspect. So with respect, it's not right to suggest that the CPS prosecutor who took the decision had no regard to this appellant's individual circumstances. Lord, no.
What's said against you is there's no sign of her ever scratching her head and saying, hang on, is she a refugee?
My Lord, no, not least because at that stage there was nothing to suggest to her that the defence under Section 31 could be made out.
Well, isn't there? She's made a claim for asylum.
She'd certainly made a claim for asylum, but heaven knows whether the CPS prosecutor actually considered this, but we know from...
Well, she says she did. She says she read all the evidence, noted the suspect's antecedent history, the suspect's interview, and discussed this case with the officer. The facts on the MG3, that's Part A...
Oh, no, she knew all that, my Lord, yes.
...are comprehensive and accurate and do not require comment.
No, my Lord, absolutely, she'd obviously read all the material that was sent to her. But the fact is that that material disclosed that the appellant had spent a year in the Yemen between 2008 and 2009, which was wholly unexplained at that stage and remained unexplained until the asylum interview and decision in May and June. And so that alone would have presented that stage an insuperable problem.
So what was the explanation in May or June when it came?
Well, what emerged in the asylum decision, just going back to what your lordships have seen, if I can take you to page MS 4282. Actually, since your lordships were looking at this, perhaps I can just go back and make another point while we've got the document open in front of us. If you go to 4280, your lordships will see under paragraph 37 the information that the government of Yemen had displayed an extraordinary generosity towards Somalis, granting all of them prima facie refugee status because of the conflict raging in their country. The Yemeni government recognises all Somalis who arrive in the country as prima facie refugees, and they are free to remain in Yemen. There are no reliable statistics on the number of Somalis living in the country. UNHCR has registered some 150,000. So what's clear from the asylum decision is that protection was offered to asylum seekers in the Yemen. See that passage. But over the page at paragraph 41, the UKBA went on to consider the conditions of Somalis living in the Yemen and concluded, paragraph 42 on MS 4282, that the article that's referred to drew attention to the appalling conditions in which they lived. And that fed into the decision at 4283, the second half of paragraph 45, which was that in light of all the objective information quoted above, it's considered that conditions for Somalis who migrate to Yemen are very harsh. Therefore, it is considered reasonable to expect the claimant to attempt to make her way from Yemen to a country where the conditions are less desperate. And that was the basis upon which the year that she spent in the Yemen seems to have been, as it were, excused by UKBA in the course of the decision that they arrived at, which was that she was a true refugee and she granted asylum. I mean, query whether, in fact, that decision would have satisfied Section 31(2) of the Act by providing a defence, because it seems on the evidence that the Yemen did offer protection to refugees from Somalia, and therefore she could reasonably have expected to be given protection under the Refugee Convention in the Yemen. But, my Lord, nothing turns on that, because in the event the prosecution was discontinued once that information was made available. And whilst I'm on the facts, can I invite your lordships to turn to page 200, MS 4305 in the appendix. Where, and your lordships have seen this document already, this was the email from Ms. Sternberg, who gave the advice that the prosecution should not continue. Now, it was suggested that she'd arrived at this conclusion, as it were, as a result of her own researches, but with respect, that's not correct. At the very top of the page, you will see she begins, further to our discussion, I've spoken to Officer in Charge Rebecca Webb. And if one goes back to her, I'm sorry to be spending some time on the facts, but if one goes back to Ms. Sternberg's witness statement, which is earlier in the same bundle at MS 4199, paragraph 16, which your lordships have seen already, but I show it to you again for a different reason. She said in terms, about 6 lines into paragraph 16, it was my view, having spoken with Officer Webb and learned of the claimant's explanation for her time in the Yemen and of the difficulties faced by Somalis living in the Yemen, the claimant would be able to satisfy the requirements of Section 31(2). So, again, this emphasises the point that it was only as a result of information provided to the CPS by UKBA, itself arising from their detailed assessment of the asylum claim, that the position that was reached as set out in Ms. Sternberg's email, and it became obvious that the prosecution should no longer continue.
Miss Webb being from
UKBA,
isn't
yes.
she? Yeah.
She was the original
Yep.
immigration officer who interviewed
Yep.
the appellant.
And we've got somewhere a date for the screening interview.
Yes, the screening interview, my lord, was on the earlier on the 28th of December. It's at MS 4251, and so far as we are aware, that was not sent to the CPS, because that's an asylum screening interview.
Well, it shouldn't have been, perhaps, but actually at some stage it clearly was.
Your Lordship's absolutely right. There's an email that raises that. Indeed,
But whether Miss Golding had it at the time she was filling in the document you've just given us is less clear. It doesn't say so, certainly.
there's certainly no evidence to suggest that she did. There was, of course, later that day, the police interview, which begins at MS 4286, which she did have, or she may well have had, and if she didn't have it, she had the detailed summary of the facts, which I've shown your lordships on the new document I've just handed up.
Yeah.
If the appellant had not been in the Yemen, would a decision to prosecute be justified?
Well, Lord, it would still have been, under the Act, it would still have been, the onus would still have been on her to make good the defence under Section 31(2).
Well, we've been told that Somali refugees are never prosecuted.
Now, my Lord, I need to correct that, because that's much too simplistic a statement. The true evidence is set out in the statement of Mr. Elliott, which begins at MS 4191. And what he said, and can I take your lordship to paragraph 11, MS 4193, was this: in our experience, which is also supported by the Home Office statistics, the majority of Somalis enter the UK illegally and claim asylum in country, by example, attending the Home Office in Croydon. In Croydon, as part of the screening process, they will be asked questions as to how they travel to the UK and how they enter the country. and will inevitably make admissions. In the last 3 to 4 years, I do not know personally of any of our clients who have claimed asylum in Croydon who have been prosecuted with document offences for illegal entry. Now, that's not this case. And importantly, he goes on, I am aware that prosecution does take place of clients who have used false documents and claimed asylum at the airport. We've acted on a number of criminal appeals of such clients who have been prosecuted. So Your Lordship is quite correct in relation to those who successfully enter the country and then claim asylum at Croydon. But my Lord, that doesn't apply to those who are, as it were, caught using false documents at the airport and who then claim asylum at the airport. On the contrary, he makes it clear that they are prosecuted, as indeed was this appellant.
Well,
presumably, yes, I mean, the assumption in the first paragraph is that it could be shown that they had committed document offences when there were people who claimed asylum in Croydon, but one wonders. Normally by that point, presumably people have abandoned their documents.
They probably have, my Lord.
but if she had managed to get into the country by use of the false documents and then claimed asylum in Croydon, she would be in exactly the same position as those referred to in paragraph 11, would she?
Well, my Lord, not necessarily at that stage, because the asylum application would still need to be processed in the way that her asylum application was processed, and a decision would still need to be made about issues such as her year in the Yemen.
What you don't know is why or for what reason. It's quite likely that there's a policy decision not to prosecute.
It may be the case.
It's also possible, I suppose, that the view is taken that anything said in a screening interview simply wouldn't be the proper basis for a prosecution, and if there isn't any other evidence, there may not be the evidence, but it seems as likely that there's a policy decision, doesn't it?
Well, that may be the case. I can't help Your Lordship about that
No,
stage.
It would seem right. I mean, if there's a policy decision which leads to the results in paragraphs 11 and 12, it's rather perverse, isn't it? The more successful you are at using the false documents, the less likely you are
Well,
to
Lord,
be.
that may reflect the different statutory provisions which apply. Your Lordships haven't been shown the statute that applies to those who enter the United Kingdom without an immigration document. It's Section 2 of the Asylum and Immigration Treatment of Claimants Act 2004. It's Volume 2 of the Authorities, page 224, tab 8, and it's MS 224. And the Lordships will see that it provides that a person commits an offence if at a leave or asylum interview he does not have with him an immigration document which is in force and satisfactorily establishes his identity and nationality or citizenship. Subsection 3, but a person does not commit an offence under subsection 1 if the interview referred to takes place after he's entered the United Kingdom and he, within 3 days, he produces a document of the kind referred to in that subsection, but it's also a defence for him to prove over the page little c he had a reasonable excuse for not being in possession of a document of the kind specified in subsection 1. And then subsection 6, where the charge of an offence under 1 or 2 relates to an interview which takes place after the defendant has entered the United Kingdom, 4c shall not apply, but it's a defence to prove that he has a reasonable excuse for not providing a document in accordance with subsection 3. That'll be 3b. So there is a different statutory regime.
Does section 31 not apply to this?
No, my Lord. That's right. Well, I say that with considerable, massive confidence. I'll be corrected if I'm wrong, but...
Well, it doesn't look as if it's listed in the...
No, that's why...
In section 31
no,
itself.
That's why I'm confident that it doesn't. Right. So, and there was some discussion in the Court of Appeal about the two regimes, But those are the regimes which Parliament has provided for, and that may go some way to explaining why the outcome is different in Croydon than it is in Stansted, at Stansted Airport. But Lord, if that is the reason, that's the result of Parliament's legislation. Lord, next, and I need to turn on to the propositions of law.
There is the difference that the people who go into Croydon can at least say that they voluntarily presented themselves.
Yes,
Yeah.
exactly.
Okay, well.
Yeah, exactly.
Sorry, I beg your pardon.
Lord, next, Mr. Hammer said that we say that in all cases it will be appropriate and proportionate to push on with a prosecution regardless of what will happen in the asylum application. Can I just remind your lordships of the guidance that was current at the time, MS 4405, and it's page 350 in the appendix. And just below the first punched hole, it remains the case that the CPS is reliant on UK Border Agency for information and evidence relevant to an assessment of whether a defence under Section 31 may apply. However, the fact that a defendant's application for asylum remains undetermined should not of itself prevent or delay prosecution or conviction. In this regard, prosecutors should also be aware where a suspect's refugee status remains to be determined by the Home Office or is the subject of an appeal, yet the suspect has complied with all the conditions set out in subsections 31 and 2, it would normally be appropriate to await the outcome of the asylum proceedings before commencing prosecution. So the policy at the time was that if all the conditions in section 31 were met, then a prosecution would not be launched, but would be postponed until the outcome of the asylum application. So there was no question of the CPS having a policy to press on regardless, as was suggested. And then, of course, that in this case raises the problem of the Yemen, which I've touched on already, which was always going to be a problem for the appellant until the outcome of the UKBA assessment. Finally, because this touches on it, my own friend Mr. Hammer said that he had scoured the transcript for day 2 of the hearing before the Court of Appeal to see if there was any reference to the concession made or said to have been made by him before the Court of Appeal. In fact, we think that the transcript provides a clear indication of my own friend making that concession. We've made copies of or copies are available of the transcript. I wonder if they could be handed up to your lordship.
Well, the same concession is recorded at first instance in paragraph 19 of the judge's judgment.
It is.
It's common ground that the advice to the effect that the evidential criteria were met was correct advice.
Well, that's right.
The challenge from the claimant is as to the decision in relation to the public interest in prosecution. That's MS 4094.
Well, that's absolutely right.
Yeah.
Thanks very much.
So where do you say that is repeated?
If your lordship would go to bottom of page 3, letter G. My own friend, can I make it plain in this?
Sorry, page which again?
Page 3, my lord.
Yep.
Yeah.
Numbering's at the bottom.
Yeah.
Can I make it plain in this case? Our Article 8 challenge is not based upon the application of the evidential test by the respondent. And then over the page, Lady Justice Gloucester says they're obviously concerned just reading the correspondence as to why she'd been in Yemen for so long, yes, and that was clearly, at least at some stage of the inquiry process, something that troubled them, wasn't it, Mr. Hammer? And it's no part of my case to say that it was not necessary or proportionate for the prosecution service to prosecute, to maintain a prosecution on the evidential test in this case. So my own friend would appear to have been accepting that the evidential test was not only made out at the outset on the 28th of May, but was also made out throughout the relevant period. And that may be because, as I've suggested, the asylum decision would appear not, in fact, to support a Section 31(2) defence. Lords,
Are we to take it, Mr. Havers, from the decision, which you showed us at 4265 onwards, I think, that all the conditions for Somalis in the Yemen was investigated, as it were, specifically for this case?
well, I can't help on that. That was a decision of the UKBA, who didn't take any part. Your Lordships will see from MS 4284 that it was signed by someone from the Asylum and Appeals team in London.
You see, what's said against you, as I understand it, if we get to justification, which is what all this is about, is you're the prosecuting authority. It may be very difficult for you to know whether the various conditions of Section 31 are in fact met. But since you've the decision to make about prosecution, it's up to you to fix up a decent system with the UKBA so that you can find out. At least I think that's what he said.
Lord, it is. Lord, I understand the point, but the reality of the situation is that the UKBA are themselves only going to investigate this asylum application once they get round to it. Whether they would have known of the position in the Yemen before they did so,
Well, that's what
or whether that was something that I would suggest that it may well be that even if they did, they would have to have revisited the position in the Yemen in order to bring themselves bang up to date.
There was a suggestion made that the individual branch prosecutor may not know, but the CPS did know, and it was an internal failure of CPS.
No, the suggestion that was made was that there was some institutional knowledge that Somalis couldn't get valid passports. That's as far as it goes.
But not about enforcement of the position in Yemen.
No,
Not about the Yemen.
It's knowledge about institutional knowledge about Somalia.
If you look at 4280, which is the section on the Yemen in the decision, the asylum decision,
Yes.
which of course isn't made for some time, June, and it's June 2010, it kicks off with a reference to a document, or more or less, paragraph 37, Human Rights Watch document from 2009, so it's comparatively recent.
Lord, it does, but at paragraph 45,
Yep.
4283, there's a reference to an article dated 25th January 2010. So they were obviously, UKBA were obviously bringing themselves up to date, making sure that their assessment was bang up to date.
Well, what matters is the information about the harshness of the conditions, doesn't it? And that seems to be, as you say, 45 and 41.
Yes.
So why does the CPS's conduct of the matter depend on the knowledge developed in relation to the asylum claim? I mean, if you're pursuing someone for an offence, don't you as a public agency owe your own duty to investigate whether there may be a defence to it?
Well, Lord,
I mean, when it came to dropping the charge, they were insistent in the emails that they were doing it because of the defence. They were insistent that it should not be seen as linked to the grant of asylum, although being commonsensical, it seems to have been pretty closely associated with it.
Well, you have to be a refugee before you get the defence, don't you?
Yes. Certainly the information about the two arose at the same time.
I see. So you can say, well, since being a refugee is integral to this defence, I can wait and see how the asylum claim goes.
Well, there are two answers. The first is that the CPS, it's simply not practical for the CPS. They don't have the expertise to carry out the sort of exercise which UKBA carried out.
I see.
They don't begin to have that expertise. Secondly, it makes no sense that you have parallel investigations being carried out by separate public bodies. But the third answer I make to Your Lordship's question is that, in fact, Section 31(2) puts the burden on the appellant to show that she could not reasonably have expected to be given protection under the Convention in the other country. So there is, in fact, no burden on the CPS to, as it were, to prove that itself. Now, I put that as my third response rather than my first.
Mr. Davis, can we just go back for a moment? Sorry, to the transcript which you've just handed up to us, I think is rather helpful, but there's a little bit more to it. You've taken us to the passage at the foot of page 3 and the top of page 4.
Yes.
But it's interesting that what immediately after the passage at B, Ms. Turner then went on to address paragraph 26 of the defence.
Yes.
Now, we've got that at MS 4128, appendix page 73. And paragraph 26 of the defence said, at Roman 2, the claimant didn't at any time fall within the scope of the statutory defence.
Yes.
Now then we get at the top of the next page, page 5 of the transcript, the clip you've handed up to us, Mr. Herman gets to that, and just above letter B, he says, Roman 2, again, is factually incorrect. Lady Justice Gloucester, but that's what they thought at the time. Mr. Herman, yes, but because they had that view, doesn't mean it was therefore necessary and proportionate not to look at individual characteristics of the case, correct or incorrect. It's surprising if that would mean it was okay not to look at the individual facts from carrying out the public interest test. So the way the argument appears to be presented in the Court of Appeal was, yes, we can't dispute that paragraph Roman 2 of paragraph 26 of the defence was correct as a statement of fact in the mind of the CPS, although incorrect in the light of subsequent knowledge. But all that's wide of the mark because the challenge was being put on the basis of failure to carry out a proper analysis of public interest.
Yeah, well, Lord, yes. I'm just seeing how it was being put in the particulars of claim. I mean, that I suppose is how the appellant seeks to translate the Article 8 challenge to the public interest, the public interest challenge into an Article 8 challenge. But that wasn't expressed to be that. It was, as your Lordship has pointed out, a challenge to the public interest part of the decision. Lords, I've spent longer than I had intended on what I hope would be a brief reply on the facts, conscious as I am that there's some important law in the case. So can I...
On the last point, the onus of proof, you say that subsection 2 is meant to be taken seriously.
I do.
Subsection 1 only applies if he shows that he couldn't reasonably expect it. That's a clear onus of proof in relation to matters within his own knowledge.
Yes, and that's what Parliament chose to provide by way of that defence. And that's the section that the CPS have to apply. That's what the law is. And I might add, they don't have to apply Article 31 of the Convention, they apply Section 31 of the statute.
The paradox is that certainly at some point it was asserted to you, I think possibly by the skeleton argument put forward by the appellant in January 2010, that Yemen wasn't even party to the Convention and that your clients accepted that. So on that basis, what more was necessary to be shown under subsection 2?
Well, that would have still provided a real problem, because the appellant still had to show under Section 31 that she came directly from a country where her life or freedom was threatened.
Yes, I see.
Now, if she spent a year in the Yemen, she plainly hadn't come directly, even allowing for Lord Justice Simon Brown's allowance for a short stop en route, or a few short stops en route. So that's why I say her year in the Yemen, which remained completely unexplained until the asylum decision, was always going to be a problem, whether it was correctly understood that the Yemen was a signatory, or whether that understanding was mistaken. Now, my lords, can I then turn to the law and begin with the first issue, legal issue, which is raised. And my lord, can I just say, explain how I propose to deal with my submissions on the law? We have sought in our printed case to set out those submissions with as much clarity as we can. So I'm not going to simply try to reformulate them in some different way. That won't be helpful. In the time that I have left, it simply won't be feasible. So I'm going to take your lordships to part of those submissions, use them as my reference point, and I'll have to do that at something of a trot, if not a canter. Lords, on the first key issue, which is Article 8 capable of being engaged by a decision to prosecute? Our submission is this: a decision to prosecute an individual for a convention-compliant criminal offence is not capable of engaging her right to respect for her private life under Article 8, because, first, the touchstone for Article 8 engagement is whether the conduct subject to interference is worthy of respect, in the sense that the individual can have a reasonable expectation of being allowed to engage in it without interference. And secondly, because criminal conduct, by definition, is not worthy of respect, and thus no such expectation can arise.
Could I just ask, when in that formulation, are you using the expression Article 8 is engaged in the same way as Counsel for the Appellant did, as a synonym for there is an interference with the Article 8 right?
Yes, my lord.
No.
Now, if I can ask your lordships to go to our printed case at 4005, you will see that we address the reach of the scope of the Article 8 obligation by reference to authorities which will be familiar to your lordships, and we don't take you to them. But we conclude at paragraph 39 with the submission that in the light of those authorities, the obligation may be defined as an obligation to respect the personal space within which each individual can reasonably expect to be left alone to live his life as he chooses, by not having public authorities encroaching or interfering into that space, save as may be justified under Article 8.2. We then address what forms of conduct can properly be considered to fall within that private sphere. And we submit paragraph 40 that the case law, both domestic and in Strasbourg, makes it clear that the critical defining factor is whether the conduct is of a type which is worthy of respect, such that the individual can have a reasonable expectation that the state will not interfere with his ability to engage in that conduct. Not all forms of conduct in which an individual chooses to engage in private will fall within such protection, nor do all means by which an individual may choose to express his or her personal identity. Now, your lordships have seen Wood already, and so I don't need to take your lordships back to it. And we quote at the foot of the page from the passage you've seen already, yes, the touchstone passage. And at the top of the next page, we also cite paragraph 25. No point me asking your lordships to take it up, where Lord Justice Law has made the same point, a reasonable expectation in the particular case that his privacy will be respected. Then can I go straight to Kinloch, which we referred to later on page 16. Your lordships will find it, volume 4, tab 34 of the authorities, MS 1280. Now, my lords, this involved police officers who were carrying out surveillance on the appellant and his associates, observing him in various public places, leaving premises, going out in cars, carrying a bag, which was then, on being searched, found to contain large sums of money, and he was indicted and prosecuted. One of the issues raised was whether what had taken place engaged Article 8. And can I take your lordships, please, to paragraph 4, first of all.
Optimistic.
Which, where your lordships will see those facts set out. And then to paragraphs 19 to 21, this in the speech or opinion of Lord Hope, with whom all the other members of the court agreed. And your lordships will see, perhaps I can ask you to read paragraphs 19 to 21 to yourselves. It'll be quicker than me reading it out to you. And obviously the passage that we particularly rely upon is at the top of MS 1294, between A and B, the criminal nature of what he was doing, if that was what it was found to be, was not an aspect of his private life that he was entitled to keep private.
Well, even if presumably he had been doing to amuse his granddaughter by pretending to be a thief, and the police had thought he was a thief, although he would have been doing it as part of his private life, it wouldn't be something in respect of which he was entitled to protection, because it would reasonably appear that he was a criminal.
Yes.
One would have thought. I mean, I think Mr. Herman's alternative would be, no, you look at the actual facts as you discover them afterwards, and that all happens under justification. But we've already debated that.
Yes.
Yeah, yes, an important aspect of the case here was the fact that the police had omitted to obtain a warrant under RIPA, with the consequence that if you got into Article 8.2, they were bound to lose on the in accordance with law requirement.
Yeah.
Lords, can I then go back to our printed case?
Kinloch was another of the cases that was looked at again by this court in the case that Lord Kerr mentioned, JR 38.
Well, my Lord, we must apologise also for not having
38.
included that in the bundle.
And indeed, it was discussed by Lord Justice Richards in the case of Queen on the application of C.
Right, whether that was that, can I ask whether that was in relation to the Article 8 part of the case or the other part of the case?
Yes, it was in relation to Article 8.
Was it? Yes.
It's 2015 UKSC 42, JR 38.
Thank you very much. I'm humbled.
You're not alone in your humility. Yes.
Well, my Lord, we will consider that authority and
Well, C, I think, is quite an important case because Lord Justice Richards discusses the Strasbourg jurisprudence in this area.
well, my Lord,
And this whole question of whether or not expectation of privacy is a touchstone, whatever that means, or whether it is merely one of a number of factors to be taken into account.
well, no, in our printed case, at paragraph 46, we go on to refer to another recent case, not quite as recent as the one your Lordship's referred to, Cat,
Yes.
in which Lord Sumption made what we suggest was an authoritative statement as to the test for the engagement of Article 8, which is, just picking it up in the sentence at the end, which has been underlined, it must extend to every occasion on which a person has a reasonable expectation that there will be no interference with the broader right of personal autonomy recognised in the case law of the Strasbourg Court. But, my Lord, even if there may be an interesting ongoing debate about whether that is the only touchstone of Article 8 engagement, it is, I would suggest, common ground that the conduct in question must be at the very least worthy of respect. And by definition, we submit that criminal conduct, or conduct that has been made criminal under a convention-compliant statute, it cannot by definition be worthy of respect. That takes us to paragraph 50 of our printed case. In between, we've looked at those cases where the issue arises, which it can do, the prior issue, which is whether the criminal offence itself is convention compliant. But that's not an issue in the present case because it's accepted that Section 31 is convention compliant. So paragraph 50, 4 lines in, we submit therefore to fall within the scope of Article 8, the activity in question must be one that's worthy of respect, and then we set out the test we suggest applies. And in paragraph 51, we set out the analogies that have been drawn not by us, as Mr. Hussain suggested, but by the judges as to examples of conduct, even conduct conducted in private, that would not be worthy of respect. Now, my Lords, paragraph 52, we go on to address how that test would be applied to a decision to prosecute. Because the interference inevitably must be the interference with what's said is the individual's ability to engage in that conduct. That's what gives rise to the charge. And so the question, we say, for the purposes of seeing whether Article 8 is engaged, is whether the conduct is worthy of respect as we've defined that above. I can take your Lordships on then to paragraph 54, where we pick up for the first time in our printed case RVG. And can I take your lordships briefly back to the Queen against G? It's volume 1 of the authorities, behind tab 6, MS 189. It seems reasonably, well, it seems in our submission very clear that not only Lord Hoffman but also Baroness Hale took the view that a decision to prosecute, well, perhaps I should go back a stage and just remind your lordships that, of course, the case was not concerned with the original decision to prosecute the appellant at all. What it was concerned with was the decision to prosecute him for what I might call the greater offence under Section 5 of the 2003 Act, rather than with the lesser offence under Section 13. And no criticism was ever made, let alone was it of the original decision to prosecute, let alone was it ever suggested that that decision engaged Article 8. Now, Lord Hoffman, in the paragraphs that your lordships have already seen, paragraphs 9 and 10, although we invite your lordships to read paragraph 8 as well, because if your lordships would turn to 8, MS 194, you will see how it was being put for the appellant. That is to say precisely that it was the decision to prosecute for the greater offence rather than the smaller offence that engaged Article 8. Then your lordships have Lord Hoffman's trenchant statement of his view that Article 8 isn't engaged at all by decisions to prosecute. And we would respectfully agree with my Lord Justice Hughes that the opening sentence of paragraph 10 is plainly addressed to whether the offence itself is convention compliant, rather than with the question whether the decision to prosecute engages Article 8. But if your lordships would then go on to Baroness Hale, I know you've seen the passage already, but paragraph 54, and indeed she makes the point in paragraph 53, no complaint is now made about the decision to continue to prosecute. But paragraph 54, the real complaint is, Parliament has very recently decided that this is the correct label to apply to this activity. In my view, this does not engage the Article 8 rights of the defendant at all. So that's her first conclusion or holding. And then her second is, but if it does, it is entirely justified. And then your lordships will see the reference later on to her conclusion at the end of that paragraph. This does not, in my view, amount to a lack of respect for the private life of the penetrating male. In other words, such conduct was not worthy of respect. Lord Hope, just going back, if I may, to paragraph 34, says about just below letter B, but where choices are left to the prosecutor, they must be exercised compatibly with the convention rights. The questions then are whether the defendant's continued prosecution was necessary and so on. So the issue that he was considering was whether the discretion to prosecute for the larger offence or the smaller offence engaged Article 8, not whether the original decision to prosecute did so. And his conclusion, as we know, was that it did. Lord Carswell agreed. And then my Lord Mance, your lordship in paragraph 68 focused on or addressed the defendant's conviction and sentencing for the offence, and then in 69 referred again to sentence, the conditional discharge, which was imposed by the Court of Appeal. And then paragraph 72, we see what your lordship said by reference to the statutory scheme as a whole, and your lordship didn't break that down between.
Well, all I said was that there's nothing in the facts which in any way could involve a breach of Article 8,
Correct.
which I hope, and I'm not permitted to say intended, because it's a matter of objective construction, but I think now left the matter entirely open.
Well, Lord, that's what we were going to suggest.
I wonder if this is the right way to look at the matter. I mean, clearly there were a number of different approaches taken in that case. It's difficult to extract a single ratio decidendi. But an alternative that I invited Mr. Hammer's comment on was to see this in a slightly different focus. The decision to prosecute involves placing before a judicial authority the evidence that somebody has committed a criminal offence. If the offence is itself convention compliant, and if there is, at least if there is evidence to suppose that has been committed, or at least there's a matter to investigate, does it involve a lack of respect for somebody's private life to take the step of placing that as well before the judicial authorities? How would a civilian country view this, or how would Strasbourg view it, if the role were being played by an investigating magistrate? We happen to have our own system of prosecution. Mr. Hammer said he was unaware of any Strasbourg authority. If it would take the law a great deal further than it's been taken at Strasbourg, then that gives pause for thought. But what I'm putting to you for your consideration is a rather different focus on the question before us.
Well, my Lord, first, the way that your lordship has analysed the position would not, in our submission, mean that the decision to prosecute engaged Article 8.
No.
That's my first response.
No, I mean, you keep talking about engaging, and we keep using different language. But yes, you would say that it is not a matter which falls within the ambit of Article 8.1, because it doesn't. It's placing the matter before the judicial authority as part of a criminal investigation is not evincing a disrespect for an individual.
No, that would be our first response to your lordship's analysis. Our second would be that, although obviously the criminal justice system here is rather different to France and other European countries where the judiciary is involved from a much earlier stage, yeah. Once the case has been placed before the court in this country, then the court is seized of it, and decisions thereafter taken about the case are taken by the court. The court manages the case. It allows or refuses applications to admit evidence and the like. It decides on bail. The court decides on conviction, and the court decides on sentence. So from that moment on, the analogy in my submission does begin to work, because thereafter the court is seized of it.
Might work better, in fact, in this country than on the continent. If the French, I mean, there have been some well-publicised French cases where French investigating magistrates have put people inside, effectively, in most unsatisfactory circumstances, and left them inside, and one would have thought that that was going to be problematic under the convention. But your point is that where you have a clear separation between the prosecutorial and investigating function and the judicial, it may be different. It may be different. It's not.
No. But, my Lord, for present purposes, my Lord, Lord Toulson's analysis would still lead to the conclusion that Article 8 wasn't engaged by the...
I detect a distinct lack of coolness to what might have been a point for your assistance.
Well, Lord, I thought I'd somewhat embraced your lordship's point.
Yeah. I mean, I've got some textbooks here. One of them is quite a fat book on human rights and criminal proceedings by Stefan Trexel. He used to be the Swiss member of the Commission on Human Rights and is now a professor of human rights law. And one finds the whole discussion is based on a presumption that once criminal proceedings begin, Article 6 kicks in, and Article 5, if there's any question of deprivation of liberty, and Article 8 deals with essentially record keeping and data. And the possibility that prosecution itself could inverted commas, engage Article 8 simply hasn't occurred to the author, or equally this textbook by Dutch writers, Van Dijk and Van Hoof. I think it's a very British way of looking at prosecution as involving the exercise of discretion by prosecutors who are distinct from the judicial authorities, that's leading us to a way of looking at the issues which I think most continental lawyers might find very alien.
Well, my Lord, the thought that a decision to prosecute might engage Article 8 hasn't occurred to anyone else either.
Well,
Because there is no...
I mean, I was going to ask you, domestically and possibly in Strasbourg, how do you deal, they're rather briefly referred to in the appellant's case, but how do you deal with cases like Purdy, Pretty and Nicklinson, where certainly in Nicklinson part of the case, and in the earlier decisions perhaps the whole, was about the exercise of prosecutorial discretion, wasn't it, and whether there should be guidelines?
Yeah, but it was about, wasn't it? Sorry, Mr. Davis, but
yes,
you've probably got a better answer.
You are hoist by your own petard.
Purdy and the other cases were about whether the conduct should be criminalised or not, and the prosecutorial discretion was invoked, whether legitimately or not is open to debate, but it was invoked as a means of controlling the criminalisation of the behaviour.
Yeah.
In other words, it went to the nature of the behaviour rather than the institution of the prosecution.
But did it? I mean, I thought that the stages in which we dealt with the Matrate and Nicklinson were, let us first consider whether it is appropriate to have this assisted suicide criminalised as such. If it is, then we turn to the question whether the guidelines for prosecution are appropriate. And that was the second criticism in the case. And it seems to me that's difficult. That's untied. That's separate from the first question of criminalisation, isn't it? It's a separate question. You assume that you have a properly criminalised statute, but nonetheless it requires to be properly administered, and therefore the guidelines must comply with the convention. Now, obviously, that's a case where you can see that the offence itself is very closely tied to personal life because it's to do with living.
Problem, I mean, the particular, I think one needs to be extremely careful about drawing broad conclusions from that very difficult piece of legislation where the DPP's consent was built into the structure of the Act. And it was perhaps a possible throwaway line by the European Court in the first of these cases to reach them, which caused the view to be taken by some in Purdy that really that the offence was only rescued not from it being a non-compliant offence by the safeguard of the DPP, and therefore the DPP had the task of reining in the law in such a way as to make sure it didn't infringe.
Yes.
Now, one can analyse it till the cows come home, but to draw broader conclusions in relation to other parts of the law may be questionable.
Yes, I mean, the issue there was that the potential interference with private life constituted by the criminal law was alleged to be so unpredictable in its operation because in practice it wasn't clear to doctors whether they were going to be prosecuted or not, that there was going to be an issue under Article 8.2 about in accordance with law, and the guidelines were then called on to supplement what was regarded as law for the purposes of deciding whether legal certainty was achieved.
Oh, yes. I mean, we respectfully agree with my Lord Towson that it is very difficult to as it were, cross-pollinate from one case to another. But, my Lord, that we can make the point, and we do in our printed case, that there is no Strasbourg authority or any domestic authority that supports the proposition that a decision to prosecute engages Article 8.
Yeah.
I mean, the G case that we're looking at the moment is not support for that proposition, and nor is the short admissibility decision that behind the next tab, tab 7 in the same bundle, MS 212. As I say, the admissibility decision, which means, as we can see, that the reasoning is set out very briefly indeed. And your lordships will note, if I could ask you to go to the foot of MS 220, page 32, that it was submitted, or rather accepted by the applicant, that the initial decision to charge him could not be criticised, confirming what was said in the domestic legislation. And then paragraph 34, the court must first determine whether Article 8 is applicable. And then some brief reference to some of the authorities, but very brief, as is the way in admissibility decisions. And then a reference to the respective ages and the conviction and sentence. And then in these circumstances, the court is prepared to accept that the sexual activities in issue fell within the meaning of private life. The court therefore concludes that the criminal proceedings against the applicant, which resulted in his conviction and sentence, constituted an interference by a public authority with his respect for his private life. But your lordships will see first that there was no suggestion that they didn't, as it were, tease out the decision to prosecute in any way from the expression the criminal proceedings, and all that they specifically referred to in that context was his conviction and sentence.
What about paragraph 39? Second sentence, court doesn't consider national authorities can be said to exceed the margin of appreciation by creating a criminal offence which is called rape. And then, last line, nor does the court consider that the authorities exceeded their margin by deciding to prosecute the applicant for this offence, particularly since the legislation permitted for a broad range of sentences and the mitigating circumstances in the applicant's case were taken into account by the Court of Appeal. Isn't that addressing separately the offence and the decision to prosecute? And indeed sentencing as a yet third aspect.
Well, my Lord, if it does, then it's a consequence of the court being, back to paragraph 35, prepared to accept the engagement of Article 8,
Yes.
which is unreasoned, as is the way with admissibility decisions. That's as far as it. That's that's the most we would suggest that one could get out of the decision in that respect. But the short and simple point we make is that the decision falls way short of any reasoned or Strasbourg authority for the proposition that a decision to prosecute is capable of engaging Article 8 of the Convention. Lords, can I go back to our printed case and to paragraph 60? Where we refer to the decision in E and the DPP, which is behind tab 5 of the same bundle. That's volume 1 of the authorities, beginning at MS 166. And the case, and I'm going to take this very quickly because I'm running out of time quite shortly. The case concerned a decision to prosecute a 12-year-old girl for allegedly sexually abusing her much younger sisters. And can I ask your lordships to go to paragraph 68, where we pick up the Article 8 challenge. And, Lord, I'm just going to leave your lordships. Can I just invite you to read 68 in your own time through to 78?
Which is page electronic?
I'm so sorry. MS 184 to 187.
Thank you.
But essentially, Lord Justice Mummy and Justice McComb held that, or came to the view that a decision to prosecute does not engage Article 8, and that was a case where the conduct was plainly within the private sphere, but was criminal, that being the key factor. Lords, two exceptions to that proposition were raised by Lord Justice Pitchford in the court below. We addressed them in our printed case, MS 4016. The first was a decision which was perverse because on the face of the known facts there was an unanswerable defence to the charge, and the second was the decision to prosecute a dying woman. Lords, as to the first, and we set this out in a little more detail in paragraph 68, there's no, that would, we suggest, fall within an obvious example of Article 8 being engaged, because if there was an obvious defence, an unanswerable defence from the outset, then the conduct in question, or there would have been an expectation on the part of the person engaged in the conduct not to have his privacy interfered with. As to the second, with respect to Lord Justice Pitchford, he doesn't explain why he says that a dying woman, that to prosecute a dying woman might constitute an interference with her right to respect for her private life. And we set out that in more detail in paragraph 69. Lords, finally, on this first issue, beginning at paragraph 91 of our case, MS 4024, we make the point in paragraph 91 that, as is pointed out in E, the researchers of counsel have failed to identify a single Strasbourg authority in which it had been held that a decision to prosecute for a criminal offence had engaged Article 8. The only case of even tangential relevance identified was Ulk against Turkey. The reference, I'm not going to turn it up, is volume 8, tab 66, MS 2648. But your lordships will see that what the court was there concerned with was the overall treatment of the applicant, which included numerous prosecutions. And their finding took his treatment as a whole, and so provides, we submit, no authority for the proposition contended for. The relevant paragraphs are 59, 62, and 63. Now, my lords, in this section of our skeleton, of our case, we look at the circumstances in which Strasbourg jurisprudence should and shouldn't be extended. It's all familiar stuff, if I may put it colloquially to your lordships. But the upshot is that we submit that...
More or less familiar.
More or less. It's more, no more, no less. But we submit that applying that principle, your lordship should not be persuaded to extend the present state of the law, which we submit is Article 8 not engaged by a decision to prosecute when Strasbourg has not done so. Lords, that takes me to issue 2. To what extent does the engagement of Article 8 depend, 1, on the nature of the offence, and 2, the likely consequences of the prosecution? Lord, and 3, the merits of the decision to prosecute, although we don't need to trouble your lordships with 3, because both sides agree that it doesn't. My lord, so far as the nature of the offence is concerned, I hope and believe that we've covered that already. I've covered that already briefly in my oral submissions, and we address it in our printed case at 4029 to 4031. So can I then turn to the consequences of the decision to prosecute, which is the primary basis upon which Mr. Hermer now puts his case. Our first response, we set out in paragraph 111, MS 4031, which is this, that that's not the test for the engagement of Article 8. As the authorities make clear, the test is, as we have submitted, whether the individual has a reasonable expectation of being allowed to engage in the conduct in question without interference. And then in paragraph 112, we make the point that your lordships have already made an argument this morning that if my friend is right, then any action by the state which affects an individual would have the potential to engage Article 8, regardless of whether the act in question encroached on his personal sphere or not. Indeed, Article 8 or its engagement would depend on the consequences of the state's, the public authority's action, including, as here, the psychological effect. Now, there's no authority, again, to support that very, very broad proposition, and that is because we submit it is obviously erroneous. But it would mean, and interestingly in paragraph 3, we had thought of the revenue, albeit in a slightly different context, but it would mean that a decision by the state to levy a tax demand on an individual might give rise to consequences, including the effect on the individual of being asked for a very large sum of money to pay what the revenues say is his debt to the state. But with respect, that cannot, we submit, give rise to the engagement of Article 8, because it would mean that in every such case, the state would be obliged to justify every action it took, which might have some effect down the line by way of some consequence for the individual's private life. My Lord, the test is as we've submitted, and not what the consequences might be somewhere down the line.
Are there, and is the scope, supposing one didn't accept your proposition, is the scope for a diversified or rather diffuse or more flexible approach to proportionality? In other words, does it always involve, under Strasbourg jurisprudence, the same intensity of review? Could there be a presumption that if you are bona fide prosecuting what is a criminal offence, then that is as far as the review on grounds of proportionality went?
Well, I'm not aware of any authority that puts forward that approach to how Article 8.2 should be interpreted.
I mean, I just wondered, because criminal law is, if you have an offence and you hand it over to the courts, as you say, by the prosecution, anyway, you can't think of any authority. There is in other areas, I think, some sign of flexibility as to the standard of scrutiny which is adopted by the Strasbourg court under proportionality.
No, there certainly may be, as it were, a level of intensity of scrutiny.
Yeah.
But your lordship is suggesting a sort of presumption in favour of
Yes, I was suggesting that you might say that in this area, so long as an offence is bona fide prosecuted, then that's the effective end of the matter. The rest is for the court, as you were suggesting. I was suggesting it as a sort of alternative possibility, but you don't know of any.
Lord, we would reject your lordships with respect alternative
No, anyway,
suggestion.
don't let me keep you up.
But it would still, of course, still mean that in every case where a prosecutor was considering whether or not to prosecute, the prosecutor would need to consider the possible consequences of him or her doing so, and to take a view as to what those consequences might be. Indeed, Mr. Hermer puts it on the basis that even if there's a risk of some consequence down the line that would interfere with the individual's private life, that would be enough to engage Article 8. And the prosecutor would therefore need to be as sure as he or she can be that that won't happen, and what's more, make sure that the decision to prosecute will be proportionate to whatever may happen down the line in terms of consequences. And that your lordships have read our printed case, that we have submitted is simply unrealistic and wholly unworkable. In paragraph 114, we make the point that, and this builds on what I've just said, that the question whether Article 8 was engaged would therefore always be conditional on what the consequences turned out down the line to be. And the answer might differ between different people. So if you prosecuted two people for the same offence, it may turn out that one suffered consequences which engaged his private life and the other didn't. So Article 8 was engaged in the former decision, but not the latter. That's what we submit the consequences argument amounts to, and the implications we set out in paragraph 120, MS 4034. And this, I think, picks up what I've already been submitting to your lordships. Not only, and this is little one, does it mean that Article 8 may be engaged by every decision to prosecute for every offence, regardless of whether the suspect was a refugee, an economic migrant, or a British citizen. But the prosecutor would have to carry out an assessment of all the potential consequences of a decision to prosecute on the individual concerned, so as to identify whether Article 8 was engaged or not. And it won't be sufficient, says the appellant, for her to demonstrate she's undertaken reasonable inquiries or can rely upon information provided by others, nor to demonstrate that her decision was correct on the information available to her at the time it was made, because the appellant submits that the obligation to act in accordance with Article 8 is one which he describes, or she describes, as one of strict liability. So if you get it wrong, if it turns out that you've got it wrong, then Article 8 was engaged, and presumably that's the end of it. Little 4, we make the point, which one of your lordships made this morning, that it's not just the potential consequences for the suspect that the prosecutor would need to address. It would be the potential consequences for others, such as the suspect's family or even the victim. And so the consequences for all of them would need to be assessed before any decision to prosecute could ever be made. How that exercise is to be carried out is not explained, but the upshot, as we've submitted, it would be wholly unworkable. And in paragraph 123 at MS 4037, we point out the difficulties that will arise in terms of timing. Not only are there some statutory limitations imposed on the periods for which individuals may be detained once arrested without being charged, so you've got to take the decision quickly, particularly in cases where there's a risk of the individual absconding. But there simply won't be enough time for the prosecutor to undertake the sort of assessment that is likely to be required in some, if not many, cases. So for that reason also, we submit that the suggestion is unworkable, and the upshot may well be that the suspect will have to be released because there isn't enough time to carry out the exercise, with all the risk of absconding that would arise. And of course, one needs to remember that in Section 25 cases, there are many such cases where the claim for asylum, the claim to be a genuine refugee, turns out to be false. That on investigation, the Home Office, the UKBA, discover that the claim that the individual in question is not a refugee at all, but is, for example, an economic migrant. So it's easy to fall into the trap of thinking that because this case is about, very much about, a true refugee, that is always the position under Section 25. Far from it, that the figures suggest something like 50% or more turn out not to be true refugees. So, my Lords, for those reasons, we submit that the consequences argument must fail. My learned friend referred to Razgar. I don't take you to it because I really am running out of time, but that was the extradition or expulsion case where the appellant, the individual who was to be expelled, claimed that the decision to expel him would have adverse psychological consequences on him. And this court held that although the usual basis upon which those decisions are held to engage Article 8 is that they directly affect the private life of the individual because they uproot him or her from their home, their community, their relationships and their friendships. In that case, it was, in an extreme case where the facts established it, permissible also to take into account the effect on their mental health. But that was still a direct effect case of interference. In other words, the decision was still directly interfering with the private life of the individual. It was not a case where there was nothing worthy of respect in terms of that which the decision was directed to, but there were consequences down the line which might give rise to an interference with the private life of the individual. There are also two other points on consequences. The first is this. If the appellant's proposition is correct, there is a risk that the CPS's role may be to some extent undermined. And by that I mean this, that the role is to prosecute those who commit criminal offences. But if every time a prosecutor has to decide whether or not to prosecute, he has hanging over his or her head, as it were, his potential liability to the proposed defendant, if it turns out that his decision has some consequence down the line of disproportionately interfering with that potential defendant's private life, that may have something of a chilling effect on how prosecutors fulfill their role. It also means that if the evidential and the PI, public interest tests, are satisfied, such that the decision which can't be challenged or criticised is that X should be prosecuted for criminal conduct, then the consequences argument would mean that despite the fact that he deserved to be prosecuted for conduct that was not worthy of respect, he may well be able to avoid any such prosecution by seeking to rely upon the consequences down the line of the decision on his private life. My Lords, that takes me then to issue 4, which we address at MS 4042. That's to say whether Article 8 was engaged by the decision to prosecute in this case. And this brings me to the myopia argument which Mr. Hermer relies upon. He says, no, it's much too narrow just to look at the conduct which fell within Section 25. You've got to look at the broader picture and address what it was that the appellant was seeking to achieve by committing the offence under Section 25. And if you do that, then obviously her journey to this country in search of asylum was very much worthy of respect, and therefore she shouldn't have been prosecuted. With great respect, that submission we submit is erroneous for the reasons that were, for which it was rejected in the court below. The conduct with which the decision to prosecute was concerned was her presentation of false papers. That's what Section 25 makes criminal, and that's what the CPS was duty-bound to prosecute if the evidential test and the public interest test were met. I say duty-bound, that's what in the vast majority of cases would follow in terms of prosecution. The conduct in question was not, and the conduct that was prosecuted was not the exercise by her of her right to asylum. Indeed, there was no interference with her exercise of that right. On the contrary, she duly claimed asylum after her papers had been found to be false, and her claim was investigated, and in due course she was granted asylum. And again, there would be consequences if Maloney and Friends' approach was accepted, and we set those out at paragraph 142. The example we give is someone who steals money to buy a plane ticket so he can visit a family member. One could think of very quickly all sorts of other examples, robbery in order to pay for IVF treatment. There's a whole raft of examples that would fall within that paragraph. But if Maloney Friend is right, then it means that notwithstanding that the theft or the robbery, or in this case the presentation of false papers, were all clearly criminal offences, no prosecution could be brought for those offences if they were committed, or if the reason for committing them was some much wider reason that did engage the private life of the potential defendant. And no authority, again, is cited to support this proposition.
Well, there's a slight difference, isn't there? I mean, it is accepted that misuse or possession of bogus papers is a common and understandable concomitant of wrongful entry into a country.
Lord, it is, and that's why section...
Or by asylum seekers, and so...
Yes.
Whereas nobody would suggest that theft is a concomitant of visiting your family member.
Lord, I completely take your Lordship's point, but when I referred to the criminal conduct under Section 25, I'm presupposing that the Section 31 defence isn't available.
Yes, that's why it's a bit circular. I mean, if it's available, then one can link the two, but we don't know it's available. So what are we doing? If
Lord,
we're saying it might be engaged because it might, the Section 31 offence might be, the defence might be available. So therefore, Article 8 might be engaged or is engaged.
Well, that's the argument under a different issue. But under this issue, the simple point being made is that by prosecuting the appellant under Section 25, too narrow an approach has been adopted. Regard should have been had to the fact that she was a refugee, and therefore she shouldn't have been prosecuted. And my simple response is, well, looked at in that on that narrow or on that limited issue, what gave rise to the criminal offence was Section 25, leaving aside the defences. And the analogy with theft and robbery is a good analogy, because the point being made is that if there was some broader reason for committing the offence in the first place, which would attract the protection of Article 8, then the offence ought not to be charged. And that, we say, it has wide-ranging consequences as well. Of course, in any event, in this case, as has been conceded, it wasn't necessary for the claimant, for the appellant, to present false documents in order to claim asylum. My Lords, I am very close to concluding, but can I just pick up the following further points? Your Lordships were taking to stubbing, and what, as I think one of your Lordships pointed out, what was there in issue was the conviction, the criminal conviction, not the prosecution. Secondly, the CPS guidance that you were taken to, 3 points. The first is that guidance postdates this case. Secondly, there's nothing in it that says in terms that Article 8 may be engaged by a decision to prosecute. And thirdly, I can tell you, Lordships, that prosecutors do not consider Article 8 when deciding whether to prosecute. They do not ask themselves the question, well, may Article 8 be engaged, and if so, can this prosecution be justified? Now, if my learned friend is right, and your Lordships accept his primary submission, then that's something that they will have to do in the future. But they don't do it at the moment.
They consider whether evidence may be excluded for Article 8 reasons and that sort of thing, but they don't actually consider whether what they're deciding. You know,
exactly. And it's no answer, we submit, to say that it doesn't really matter if Article is engaged or not, because in most cases the decision to prosecute will be found to be proportionate. The point is that in every case the prosecutor will need to address the question whether Article 8 is engaged, and that will mean that he has to address, and I'm repeating myself, what might be the consequences down the line. Lord, so far as the Criminal Cases Commission documentation is concerned, I can't comment on other cases. Your Lordships are concerned only with this case, which is a claim for damages for the decision to prosecute in December 2009. Lords, finally, on the UK, on the Human Rights Commission's intervention, all I would say is this. Obviously, your Lordships are concerned with Section 31, not Article 31. Article 31 does not form part of or confer rights under domestic English law. One of the authorities in the bundle, Pepushi, Volume 5, Tab 42, MS 1720, explains that at paragraphs 25 to 27. So the law that the CPS was bound to apply was Section 31. Secondly, the general proposition that asylum seekers should be treated as presumptive refugees was reflected at the time by the CPS's policy, which I took you to a little earlier, which was that normally, if all the elements of Section 31 are satisfied, a decision to prosecute will be postponed until the outcome of the asylum application. And, my Lords, that's all I would wish to add by reference to the Commission's submissions. Unless we can assist your Lordships further, those are our submissions.
Thank you very much indeed. Mr. Sheldon. Yes, Mr. Hammer.
My Lords, a few minutes on the facts and then the remainder of the short amount of time I have on the law. Facts. My learned friend suggested at the outset that the initial decision to prosecute was based upon a belief that the Section 31 defence was not available because of the year-long stay in Yemen. In fact, that is not right. at the time the decision was made, it was made on the basis of a belief that the defence wasn't available because of the stopover in Holland. You'll find that MS 4360. 4360. Do you see that? She's arrived from Holland, an EU member state. Sorry, it's 4360, second paragraph. She's arrived from Holland, an EU member state, as signatories of the 1951 Convention, and therefore cannot engage defences or protection from prosecution under both Article 31 or Section 31. Yemen does not raise its head until the 29th of April. See page 4338. And this is only after, my lords will pick this up from the references I gave you towards the end of my submissions this morning about the decision-making process. This email is only generated for 4338 after the UKBA, on 2 occasions, say to the CPS they think the case maybe should now be dropped because, having considered as for, Holland might in fact not deprive the appellant of a Section 31 defence. And it's only now, on the 29th of April, that the CPS raised the question of Yemen. Flowing from that, my learned friend's submission was that, as a matter of fact, it was practically impossible, or at least very difficult, for the CPS to obtain information after the 29th of April about Yemen. And that information only came from the UKBA. But it is certainly right, and my learned friend has shown you that that was a matter that was considered in the asylum application, but it was also a matter that was considered and researched by Miss Sternberg of the CPS in the 7 days it took her to get to the bottom of the case. We can see that from my learned friend's printed case, paragraph 32, MS 4004. Paragraph 32, you'll see this is dealing now with Yemen, Roman numerals 2, Ms. Sternberg's independent research into the general circumstances faced by Somalian refugees in Yemen. The former, the latter, this is the bit that's relevant, was at least potential relevance to both the evidential and public interest elements in the test. And then if we go back to the email we've now looked at twice at 4305, now, it's clear, as my learned friend says, there's some discussion with the border agency, but then third paragraph is her understanding of the claim is based on background membership of the clan based within Somalia. Contrary to the views previously expressed by the UKBA and CPS, Yemen does in fact recognise the convention, uniquely in the Arabian Peninsula, and the asylum status is confirmed on Somalian refugees. This information is readily available, it is said, on the UNHCR website. So it was information that the CPS was perfectly capable of obtaining. But in any event, as my lords know from my submissions this morning, it's our case that even if this wasn't information that the CPS had readily available, institutionally, as they did the issue about the non-availability of travel documents, even if this information was not readily available and couldn't be obtained, contrary to Ms. Sternberg's experience, it was the type of information that they could and should have obtained from the UKBA, not least in the context of what has been going on with prosecutions over the course of at least a decade. One or two other small matters of fact. You were taken to Mr. Elliott's witness statement, 4194. My Lords, it's perfectly clear from the statement at paragraph 11 that Mr. Elliott is referring to decisions not to prosecute for section 25, because we can see that just at the beginning of the top of page 4194. In Croydon, as part of the screening process, they will be asked questions as to how they travelled to the UK and how they entered the country, and will inevitably make admissions that they travelled on false papers. So that would be a section 25 offence.
Oh, yes. But what about the use of the admissions, Mr. Hermberg?
Well, that is an admission that admits to several of the key constituent elements of an offence under section 25.
It's not an interview conducted under caution, is it?
It's not an interview. Well, my Lord, that is correct, but it doesn't seem to be the case, or the suggestion from the evidence, that the decision not to prosecute is based upon a non-admissible interview.
Don't know.
Well, it presumably is, isn't it? I mean, if they don't have any evidence apart from this, how are they going to make their case?
Because there's no evidence that they then seek to refer to the police, who would then interview under caution. Which is what the border agency would do. If they think a criminal offence has been committed, they'll bring in the police and they would interview under caution.
Always then be an interview under caution, is what you're saying.
Absolutely.
Yes, I follow.
So there's no evidence that there's actually a systemic failure to forget to caution people when they're making admissions about their false identity papers. To the contrary, what appears to be the case is there's a decision that if you claim in country and you make an admission that you used false documentation, the decision is taken not to prosecute. And that's what Mr. Elliott is referring to. And if in fact they had ripped up their documents before entry and were charged with an offence under section 2 that my learned friend took you to, they would have a complete defence there, because they would have a reasonable excuse. They ripped up the false documentation. They would have a reasonable excuse, defence, if they could show they were from a country where they could not have got genuine documents. And my Lord's authority for that is the case of Fett, which you'll find in Volume 6, tab 49, MS 1939. My Lords, can I just respond very briefly then on the legal submissions? Oh yes, I should note also, when I've asked you to look at 4357, which is the charging decision, just for your note, at that stage it's deemed that the investigation is complete and there exists no prospect of further evidence. That was the decision taken on 28th of December 2009. So, turning to the law, two tests, my learned friends say, have to be satisfied before Article 8.1 can even be engaged or brought into play. First, a reasonable expectation of privacy, and secondly, that criminal conduct is not worthy of respect. My Lords, the expression reasonable expectation of privacy is an expression that is found in cases that are classic privacy cases about the retention of information or the dissemination of images, etc., in which it would be self-evident that if there was an expectation of that information being kept private, there can be no engagement with Article 8.1. There's nothing to suggest that that is a term of art that has application in the wider sense in which Article 8.1 has been said to operate. As to criminal conduct not worthy of respect, well, my Lords, this is obviously a very clear dividing line between the appellant and the United Nations on one hand and the respondent on the other. We emphatically submit that it is entirely inappropriate to seek to categorise the entry into this country on false documentation for the legitimate purpose of seeking asylum as criminal conduct not worthy of respect. That we say is irreconcilable with great respect with the long-established views of the United Nations, reflecting the views of the international community. It is irreconcilable with the decision of Parliament to introduce Section 31 to give effect to Article 31. And it is a type of legal analysis so divorced, we say with great respect, from reality and humanity, that it has no place as a means of analysis of an article sitting in a human rights convention.
Once you accept, if you have accepted, that the evidential burden is established, doesn't that mean to say that there was, at the charging point, a prima facie at least case, a sufficient case to justify subject to public interest consideration?
Well, the subject to public interest is an important caveat.
It doesn't mean, the public interest doesn't mean, say, the offence hasn't been committed, though.
Well, my lord, the appropriate comparator, we would say, is this. The appellant is no more culpable of criminal behaviour or engaging in conduct not worthy of respect than an individual who punches another in self-defence. So some of the constituent elements of an offence under Section 20, the offences against the person act, might be made out, but there's a complete defence. One would never describe that as criminal conduct, nor conduct not worthy of respect. One final reference on that, which is the question of presumptive refugee, and whether or not the framework covers presumptive refugees as to whether those who are later declared to be refugees. See ADEME 677H at MS 78, and see my learned friends Mr. Hussain and...
Sorry, 677H at MS...
78.
Yeah.
And see the High Commissioner's submissions between paragraphs 29 and 37. My lords, on the question of whether or not the test under 8.1 is a subjective test or an objective test, I don't wish to repeat my submissions as to why it is objective. But insofar as there is any element of subjectivity, then we do stress that the question cannot properly be one for the purposes of engagement of Article 8.1 as to what the CPS, or limited to what the CPS did know. It must be, if you are going to allow an element into subjectivity as to whether a human right has been engaged, it must be in those circumstances what they ought to have known. Otherwise, you're catering for potential failures and oversights by the public authority. It'll be the actions of the public authority that define whether or not a human right is engaged. We say with respect that can't be right as a matter of first principle. My lord, dealing with my Lord Toulson's point about civil society and investigating a juge, this country is different, obviously, to an investigating magistrate, and at no stage does the Crown Prosecution Service actually hand over responsibility to a court. It remains seized of the prosecution. But ultimately, whether or not the analysis can be applied or cannot be applied to a civil law system, the question for Article 8 must be one of principle. And the key question, we would say, can boil down to whether or not it is a coercive act of a public authority that impacts upon the autonomy of the individual in a manner described by the authorities. Now, which arm of state happens to do that, whether it be a public prosecutor or a court, is irrelevant.
So pause there, because that takes at least me straight back to the way that you've pinned this very largely on the public interest part of the test which is applied in this country by the CPS. Now, suppose a system such as I believe to be true of Germany and Italy and several other Code Napoleon countries, where the duty of the public prosecutor, according to either a constitution or a basic law, is to present a prima facie case to the court wherever it is disclosed. In other words, there is no public interest element
Yes.
in the prosecution decision. Does it follow that those provisions are vulnerable to attack under Article 8?
Well, it may not be those provisions per se,
Well,
but
I
if,
mean,
if, if,
individual
the,
case.
if the prosecutor in a Lanza or a juge makes a decision that is a coercive act that impinges upon the autonomy of the individual, then that decision maker will have to justify as necessary and proportionate under Article 8.
Yeah, and he won't be able to justify it by saying, hang on, it's an absolute fundamental part of our ethic and our constitution that I am required to bring the case to court if there is a prima facie case, because I think you'll find that is the law.
Well, my lord has the advantage over me, I'm afraid, just in terms of knowledge of the German.
But it's one reason why we are said to get so many extradition applications from certain East European countries. So there's an automaticity about pursuing them.
It's certainly true that there's something in the German basic criminal law, and there's something in the Italian constitution to precisely that effect.
Yes.
And those aren't juge d'instruction type systems. They're systems of public prosecutors who, as Lord Reid pointed out earlier on, are regarded as part of the judiciary, but never mind. They're public prosecutors. But it is certainly true, as I understand it at least, that there has been some relaxation of the duty so that in some cases it is possible, as it were, for prosecution, for a decision to be made not to prosecute. But generally, the fallback, the starting point is, if the evidence is there, the case must be taken to court.
Well,
and I mean, it's all to do with, it's all connected with the way in which the continental systems don't, for example, have anything like the same system of pleas of guilty that we have. You have to prove the case.
yes.
It's also connected with history.
Yes, very much so.
You know, discretion is viewed as dangerous. But I think, I mean, if this were Strasbourg, the Strasbourg court would certainly consider this sort of point, and it might be helpful if both of you did and put in something.
Well, I was going to ask, because I'm embarrassed that we haven't considered the continental system and the civil law system.
I mean, the point is obviously a serious one, because on your
It
case,
is.
potentially, that sort of system is itself contra to the convention in not allowing any discretion.
Well, my lord, it may be, and we'll need to look at, not least research why there might be a broadening of that approach, and seek to assist the court in whatever way we can with
Well, I think
that.
we'd have to have a time limit, and I appreciate we've asked you to broaden the horizons rather, but and don't feel you've got to go to every country in Europe. But I think it might be interesting. My lord's referred to Germany and Italy. It might be interesting.
I'm particularly interested in the possible view that when you're in the territory of the investigation of criminal investigation, that it's Articles 6, 5 and 6 that are seen as providing the protection. It's not regarded on the other side of the water as Article 8 territory. Now,
Yes.
That's clearly a matter of investigation.
Yes. Well, my lords, we'll certainly undertake to do that and to provide you with a note and any relevant materials.
Yes, well, we've got the vacation coming. You're not going to get an answer this side of the vacation anyway, so that it would be helpful if you did it within, would 3 weeks be realistic, or 4 weeks?
I was going to ask, my lord, just if it's not going to inconvenience the court, whether it's early September, if that would be a possibility for the court, but I'm entirely in the court's hands, obviously.
I think that's probably going to be acceptable.
Well, I'm
If you want, incidentally, to look at JR 38, it's in the 2015 3 weekly law reports, page 155.
Thank you, my lord. Well, we'll provide that note, and we're grateful for the extension. Otherwise, might have engaged my Article 8 rights. I'm very grateful. Could I just deal finally, well, almost finally, re-E, my learned friend referred to the decision of Lord Justice Mumby. See for your notes, paragraph 77 to 8, where his lordship makes plain that this is entirely thinking out loud and best explored when the Court of Appeal had the benefit of a judgment below dealing with it. And his lordship identifies only the judgment of Lord Hoffman as the obstacle in the way. So it doesn't take it further. And nor, my lord, do we say does the absence of a Strasbourg case take it any further. This isn't Ulla territory. This is about principle, about how Article 8.1, when it is in play, and then proportionality, which is entirely straight forward. Could I end, if I may, by addressing the floodgates arguments and the understandable concerns that those who respect my learned friends will have about what the implications of this case would be were the appeal to be allowed. My lord, there are at least two controlling mechanisms that mean that succeeding in this case would not result in a barrage of claims against the Crown Prosecutor, less would they impact upon the day-to-day work of Crown Prosecutors. Firstly, if the court were to accept my narrow proposition of when Article 8.1 is brought into play, when it is engaged, where there is conduct that is worthy of respect, it is unlikely to arise in very many cases, because most prosecutions arise out of criminal acts that are not worthy of respect. And for the reasons that I have advanced and that Mr. Hussain has given eloquent emphasis to, this is almost unique by way of criminal offences because of the existence of Section 31 and the international context. So that is controlling mechanism number one, if the courts reject my broader notions of where 8.1 is engaged.
Is it a sliding scale according to how confident you are that there may or may not be a defence? I mean, your primary case is that you judge whether the conduct was worthy of respect by looking at the position now, but assuming that's wrong and you look at the position as the prosecutor would have looked at it, have they got to say, well, I must decide whether Article 8 is relevant according to my view of the likelihood that I will be able to establish guilt? Because if, of course, this person is innocent, then it would be terrible to prosecute them and put them to all the trouble. But I think there's a pretty good case, and therefore I can be a bit less worried about that and more ready to prosecute. Is it a factor, therefore, of that nature?
Yes, I mean, possibly, my lord. I mean, what I was seeking just to stress under this point, and I'm sorry if
We were saying here, this is a case of innocence, and therefore it's monstrous to prosecute, and one understands that argument, but that's looking at it ex post facto.
Well, that's again why I'm seeking and have sought throughout to draw this distinction between the two questions that you need to ask, which is under 8.1, are we in play, and under 8.2, is it justified? Now, under 8.1, you don't take those into consideration, we would submit, for the reasons that I've given. You simply ask yourself, was it a coercive measure in respect of conduct that was worthy of respect, to take the narrow view of the engagement of Article 8.1. Now, whether or not that was a reasonable view to come to or an unreasonable view to come to, whether what they knew and what they ought to have known are all matters that come into the next stage, which is 8.2. And that's why in Schedule 7, stopping at the airport engages Article 8, but it's easily justified. The threshold here is in that context. But that is controlling mechanism number one, under 8.1. So even to get into Article 8 territory, there's a very significant controlling mechanism, because most prosecutions are not going to be in respect of conduct worthy of respect.
Yes.
And the second point, for all the reasons that I'd set out this morning, is that in the vast majority of prosecutions, a decision to prosecute, applying the code of conduct for Crown prosecutors, is going to produce a proportionate result. And that is why I stress the unique, perhaps, context of this case, which is this can't be seen in isolation as a one-off decision, a one-off chain of events leading to a decision to prosecute someone who was in fact a refugee and had very good reasons why she had false papers. It falls into a pattern that the respondent has been aware of for over a decade of repeated error, leading to miscarriages of justice, leading to very severe detriment, as we can see from this case from the medical evidence, including physiological detriment of very vulnerable individuals. And that's why, my lords, we say in this case, on the narrower analysis advanced by the appellants, there is no real concern, or should be no real concern, about floodgates, nor should there be any real concern that there would be anything that would impact deleteriously on the decision-making at this Crown Prosecution Service. My lords, those are my submissions.
Thank you very much indeed. Well, the Court's grateful to counsel on both sides and those who've prepared the case and will take time to consider its judgment.